You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Biometric identifiers are unique physical or behavioral traits that can be used to recognize individuals, and several state statutes define them in precise but slightly different ways. Commonly covered identifiers include fingerprints, facial geometry, iris and retinal scans, and voice prints. These are treated differently from other personal data because they are immutable. If a credit card number is stolen, it can be replaced, but if a fingerprint template is exposed, it cannot be changed. This permanence creates heightened risk, making biometric information especially sensitive. Some laws also extend their definitions to include hand geometry or DNA, while others carve out exceptions for photographs or recordings, unless used to create biometric templates. Learners should think of biometric identifiers as digital keys tied directly to the body. Their convenience in authentication is powerful, but the consequences of misuse or compromise are lasting. This fundamental quality explains why states impose such rigorous rules. The most common use cases for biometrics appear in authentication and access control. Organizations deploy fingerprint scanners or facial recognition systems to verify identity for building entry, secure system logins, or point-of-sale transactions. Timekeeping is another frequent application, where employers use biometric clocks to reduce buddy punching by employees. Fraud prevention is also central, with banks and retailers increasingly using voice recognition or facial scans to confirm identity in high-risk transactions. While these tools promise efficiency and stronger security than passwords, they also raise privacy and fairness concerns. For example, a time clock that records fingerprints may unintentionally retain sensitive data beyond its immediate use, creating liability if not managed properly. For learners, it is useful to compare biometrics to a house key. While highly effective at securing entry, it must be safeguarded diligently, because once copied, the entire system is compromised. Illinois' Biometric Information Privacy Act, or BIPA, is the most influential and widely discussed of these statutes. One of its central requirements is that organizations adopt a publicly available written policy describing how biometric identifiers will be collected, stored, used, and destroyed. This policy must also include a retention schedule, ensuring that biometric data is not held indefinitely but deleted once the purpose for collection has been fulfilled or within a statutory time limit. For example, an employer using a fingerprint-based time clock must publish a clear policy that fingerprints will be deleted within 3 years of the employee's termination. By requiring organizations to plan upfront for retention and destruction, BIPA forces them to treat biometrics not as permanent records, but as sensitive tools tied to specific, time-limited needs. This written policy is both a compliance obligation and a transparency mechanism for affected individuals. Another cornerstone of BIPA is the requirement for informed written consent before collecting biometric information. Companies must notify individuals in writing about the purpose of collection, how the data will be used, how long it will be retained, and whether it will be shared. Consent must then be captured in writing, often through a signature or electronic acknowledgement. For example, a school district that introduces fingerprint scanners in cafeterias for meal payment must provide parents with written notice and secure their consent before enrolling children. This standard reflects the idea that biometric collection cannot be passive or hidden. It must be an explicit agreement with the individual. Learners should recognize that this goes beyond typical click-through agreements. It demands meaningful disclosure and documented acceptance, underscoring the heightened sensitivity of biometric identifiers. BIPA also places strict limits on the sale and disclosure of biometric information. Organizations are prohibited from selling, leasing, or trading biometric identifiers, and they may not disclose them to third parties without consent or legal authority. This addresses concerns about the commodification of biometrics in marketing or data brokerage markets. For example, a fitness club cannot share fingerprint scans collected for member access with an advertising partner, even in aggregated form, unless explicit consent has been obtained. This rule highlights a broader theme in biometric regulation: the idea that biometrics are fundamentally different from other identifiers because of their permanence and sensitivity. Preventing their sale or casual disclosure helps ensure they remain tools for secure authentication rather than products in a data marketplace. What makes BIPA especially impactful is its private right of action, which allows individuals to sue organizations directly for violations. Statutory damages are available on a per-violation basis, often ranging from $1,000 for negligent violations to $5,000 for reckless or intentional ones. Because each scan or disclosure can be treated as a separate violation, damages can escalate quickly in class action litigation. For example, a retailer that uses fingerprint scanners for employee timekeeping without obtaining written consent may face lawsuits from hundreds of employees, each entitled to damages for every scan. This enforcement mechanism distinguishes BIPA from other privacy laws that rely solely on regulators, creating powerful incentives for organizations to comply. Learners should appreciate that BIPA's litigation model has influenced debates nationwide, making it a touchstone for discussions about biometric privacy. Washington also regulates biometric information, but its statute focuses more narrowly on notice and consent during enrollment. Businesses must provide clear notice before capturing biometric identifiers and must obtain consent before using them in a commercial context. Unlike BIPA, Washington's law does not provide a private right of action but instead relies on the Attorney General for enforcement. For example, a retailer introducing facial recognition for theft prevention would need to notify customers and secure their consent. This law reflects a more modest but still significant recognition of biometric sensitivity. It highlights a trend where states adopt BIPA-inspired protections but balance them with narrower enforcement mechanisms, reflecting different policy choices about the role of private litigation in driving compliance. Beyond consent, Washington's statute also requires safeguards and deletion when the purpose for collection has been met. Organizations must implement reasonable security measures to protect biometric identifiers against unauthorized access, and they must delete the data once the purpose has been completed or within a reasonable time frame. Consider a company using voice recognition for call center authentication. Once an account is closed, the associated voice print should be purged from the system. This approach reinforces lifecycle management, ensuring that biometrics do not linger in storage long after their usefulness has ended. By coupling security with deletion duties, Washington demonstrates the dual obligations of protecting biometric data, both while it is held and by ensuring it is not retained unnecessarily. Texas, too, has a biometric privacy law with its own emphasis. It requires consent before capturing biometric identifiers and prohibits their disclosure or sale without authorization. Consent here must be obtained before capture, not after the fact, ensuring that individuals have a meaningful choice about whether their biometrics are used. For example, an amusement park installing fingerprint-based season pass entry must inform guests and obtain their consent before enrollment. This requirement reinforces the principle of informed choice, which has become a cornerstone across biometric statutes. By prohibiting disclosure and sale, Texas aligns itself with Illinois and Washington in rejecting the commodification of biometrics, even if its enforcement mechanisms are different. Texas's law also addresses retention and security. It requires that biometric identifiers be destroyed within a reasonable period, typically not later than 1 year after the purpose for collection has been fulfilled. Organizations must also implement safeguards to protect biometric data from breaches or unauthorized access. For example, a financial institution using iris scans for high-security vault access must delete those scans once the account is closed and maintain encryption or other protective measures while the data is in use. This mirrors the lifecycle approach seen in Washington and Illinois, underscoring that biometric governance involves both front-end consent and back-end destruction. The combination of retention limits and security safeguards reinforces accountability across the entire biometric data lifecycle. Employee and consumer contexts present distinct challenges in biometric regulation. In workplaces, employers often introduce biometric systems for timekeeping, access control, or device login. Laws require employers to provide notice and obtain consent from employees before enrolling them, and this often includes collective bargaining considerations in unionized environments. In consumer contexts, consent must be adapted for clarity and accessibility, ensuring that ordinary customers understand the scope and purpose of biometric use. For example, a gym requiring fingerprints for locker access must notify members clearly and obtain their consent, just as a bank using facial recognition at ATMs must inform customers. These dual contexts illustrate how biometric rules must be flexible enough to apply across relationships with different power dynamics and expectations. Children's biometric data is treated with heightened sensitivity across all statutes. Because children may not fully understand the implications of biometric collection, additional protections are required, often involving parental consent. For instance, a school that wants to use facial recognition for cafeteria payments must provide detailed notice to parents and secure verifiable consent before enrolling students. The heightened standards reflect recognition that children are a vulnerable group and that misuse of their biometric information could have long-lasting consequences. Learners should see this as part of a broader theme in privacy law. When populations are more vulnerable, the obligations for transparency, consent, and safeguards become stricter, ensuring that protections are proportional to the risk. Biometric laws vary significantly in definitions, exemptions, and enforcement mechanisms, creating a patchwork that businesses must navigate. Illinois includes private rights of action, while Washington and Texas rely on attorney general enforcement. Some states exempt certain uses, such as biometric data collected for security purposes or stored in photographs unless transformed into biometric templates. This variability complicates compliance, requiring organizations to analyze the specific rules in each jurisdiction where they operate. For example, a company with employees in Illinois and customers in Texas must design a program that satisfies both sets of obligations. For learners, this demonstrates why harmonization strategies are important and why businesses often adopt the strictest applicable rules as their baseline. Beyond states, emerging municipal and sector-specific rules are shaping the biometric landscape, particularly around facial recognition. Some cities have banned government use of facial recognition, citing concerns about accuracy, bias, and surveillance. In retail and aviation sectors, industry-specific standards are being introduced to manage risks. For example, airports deploying facial recognition for boarding must follow federal aviation guidelines alongside state privacy laws. These developments show that biometric governance is not confined to state legislatures but is increasingly multi-layered, reflecting diverse societal concerns. For learners, it is a reminder that compliance is dynamic. Organizations must monitor not only state statutes, but also local ordinances and industry rules that can impose additional constraints on biometric deployments. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Strong program governance is essential for organizations deploying biometric systems. Governance means assigning clear roles, such as owners who are accountable for the system, stewards who manage day-to-day operations, and approvers who review policies and ensure compliance. Without these roles, biometric programs risk becoming fragmented, where no single person is responsible for oversight. Imagine a company introducing facial recognition for building access. The facilities team might handle installation, IT might manage storage, and HR might handle employee onboarding. Without a designated owner, gaps can emerge, such as failing to update policies or review retention schedules. Governance structures prevent these blind spots by creating accountability from top to bottom. By designating owners and approvers, organizations can demonstrate to regulators and employees alike that biometric systems are managed with the same rigor as financial or safety programs, reducing both operational risks and legal exposure. Privacy notices for biometric systems must be precise and thorough. These notices should clearly explain the purposes for which biometrics are collected, such as authentication or fraud prevention, the recipients who may access the data, and the retention limits governing how long the information will be kept. A vague statement like, "We may collect biometrics for security purposes," is not sufficient. Individuals must understand what specific identifiers are collected, how they will be used, and when they will be destroyed. For example, an employer should explain that fingerprints will be used solely for timekeeping, shared only with the payroll processor, and deleted within 3 years of employment termination. Detailed notices build trust by allowing individuals to make informed decisions, and they reduce the risk of deceptive practice claims. They also set the baseline for consent, ensuring that what is communicated up front matches actual system operations. Consent capture mechanics are equally critical, and they must go beyond perfunctory signatures. Organizations should use clear, plain language forms or digital workflows that explain the collection, use, retention, and sharing of biometric data. Consent must be voluntary, specific, and informed. For instance, if a company deploys voice recognition for customer service authentication, it should provide callers with an option to opt in after hearing a clear explanation of how their voice prints will be used and retained. Revocation must also be supported, meaning individuals can later withdraw consent, triggering cessation of use and deletion of their templates. This creates an ongoing dialogue rather than a one-time transaction, reinforcing respect for autonomy. Learners should view consent as a continuous relationship. It begins with clear disclosure, is documented through affirmative agreement, and remains valid only as long as individuals are comfortable with the arrangement. Security in biometric systems must also address spoofing and presentation attacks. Liveness detection is a technical safeguard that ensures a biometric sample is coming from a real, live person rather than a static image, recording, or synthetic replica. For example, facial recognition systems may require users to blink, smile, or turn their head to confirm presence, while voice recognition systems may request random phrases to prevent playback attacks. Without liveness checks, attackers could exploit biometric systems using photos or stolen recordings. Incorporating spoofing resistance demonstrates a higher maturity level, showing that organizations are not only storing biometric data securely but also collecting it responsibly. This reflects the idea that biometric security does not stop at encryption or retention. It must also protect the integrity of the data capture process itself. In practice, this builds both safety for users and defensibility for organizations if challenged by regulators. The way biometric templates are stored is just as important as how they are collected. Best practices include encrypting biometric templates at rest and in transit, isolating them from general data stores, and applying strong key management protocols. Templates should never be stored in raw form, such as image files of fingerprints or facial scans. Instead, they should be converted into mathematical representations that cannot easily be reverse engineered. For example, a voice print might be stored as a hashed set of vocal characteristics rather than an audio recording. This reduces the risk of exposure even if databases are compromised. Key management ensures that encryption itself is not undermined by weak controls. Organizations must also plan for key rotation and restricted custody, ensuring no single individual has unchecked access. Learners should understand template architecture as a structural defense. It minimizes the consequences if outer defenses fail. Role-based access controls are another safeguard, ensuring that only authorized personnel can view or manage biometric systems. Audit logging should track who accessed biometric databases, when, and for what purpose. Segregation of biometric stores from general IT systems reduces the risk of accidental exposure or insider misuse. For example, an HR manager may be permitted to enroll employees in a fingerprint system but not to access the encrypted templates themselves, which remain under IT security's control. Every access attempt should generate logs that can be reviewed during audits. These measures reinforce accountability by showing that biometric data is not casually accessible. In practice, access controls and audit trails act like security cameras in a vault. they don't just protect against intruders, but also deter misuse by insiders who know their actions will be recorded and reviewed. Vendor contracts play a vital role in biometric system compliance. Any third party involved in providing biometric technology, such as software vendors or cloud hosts, must be bound by contractual terms that address accuracy, security, and deletion. Accuracy is critical because flawed models may produce biased or discriminatory outcomes. Contracts should also require vendors to meet industry security standards and to delete biometric data promptly upon termination of services. For instance, if a school contracts with a vendor to manage fingerprint-based cafeteria payments, the vendor should be contractually required to destroy all templates once the contract ends. These provisions prevent biometric data from drifting into unintended uses. By embedding these protections into contracts, organizations extend their compliance framework beyond their walls, ensuring vendors are equally accountable for protecting sensitive identifiers. Retention schedules for biometric data are central to compliance. Biometric identifiers must be retained only as long as necessary for the purpose that justified their collection, after which they should be securely destroyed. Organizations should document these schedules in their policies and provide verification that destruction has occurred. For example, an employer might set a policy to delete fingerprint templates within 3 years of an employee's departure and then record a destruction certificate confirming completion. Exceptions must also be documented, such as when legal obligations require extended retention. This discipline reinforces the principle that biometrics are not permanent archives but temporary tools tied to specific needs. By treating destruction as a compliance event rather than an afterthought, organizations demonstrate responsibility and reduce risk of liability if challenged. Data subject request handling is another requirement that tests operational readiness. Individuals must be able to request access to their biometric information, demand deletion, or obtain copies of applicable policies. Organizations should have workflows in place to receive, verify, and respond to such requests within statutory timelines. For example, an employee might ask for confirmation that their fingerprint template has been deleted after leaving a company. A compliant organization should be able to produce records showing deletion and provide a copy of the retention policy that governed the action. These processes transform abstract rights into practical realities, giving individuals meaningful control over their biometric identifiers. For learners, the key lesson is that rights handling is not optional. It is a core test of whether a biometric program is functioning responsibly. Incident response for biometric compromise presents unique challenges. Unlike passwords, biometrics cannot be reset once exposed, so organizations must design fallback options such as credential replacement pathways. For example, if a facial recognition system is breached, affected users might be issued secure tokens or multi-factor authentication alternatives to replace compromised credentials. Incident plans must also include regulator notifications, consumer communication, and forensic investigation to prevent recurrence. Treating biometrics as irreplaceable underscores the need for stronger prevention, but it also demands thoughtful remediation strategies when failures occur. For learners, the lesson is sobering. The consequences of biometric breaches are enduring, making proactive security and prepared contingency planning all the more essential. Training the workforce is often overlooked but is critical in maintaining biometric compliance. Employees who manage collection points, such as HR staff enrolling workers or customer service agents assisting with voice recognition, must understand the legal and procedural requirements. Training should cover how to provide notices, obtain valid consent, troubleshoot systems, and handle withdrawal requests. For example, a retail associate responsible for onboarding new members into a fingerprint-based access system should know not only how to operate the device, but also how to explain the privacy notice and confirm written consent. Regular training ensures consistency and reduces the risk of accidental noncompliance caused by human error. It also signals to regulators and consumers that biometric governance is an organizational priority, not just a technical implementation. Risk assessments and bias testing are vital for advanced biometric systems, such as facial or voice recognition. These technologies are susceptible to inaccuracies that can disproportionately affect certain demographic groups, leading to discrimination claims. Organizations should periodically test their systems for false acceptance and rejection rates, disaggregated by age, gender, and ethnicity, and document remediation steps if disparities are found. For example, a voice recognition system that struggles to recognize accents may unfairly disadvantage non-native speakers. By conducting bias testing and risk assessments, organizations ensure that biometric systems are both secure and equitable. For learners, this highlights an evolving dimension of biometric governance, protecting not only privacy but also fairness in the deployment of high-stakes technologies. For companies operating across multiple states, harmonization strategies simplify compliance. Because definitions, exemptions, and enforcement vary, businesses often adopt the most protective requirements as their baseline. This might mean following Illinois' stringent consent and retention rules even in states without private rights of action, or adopting Washington's deletion standards universally. By creating a common baseline, organizations reduce the complexity of fragmented compliance while elevating consumer protection. For learners, harmonization illustrates a proactive approach. Rather than playing catch-up with each jurisdiction, businesses can position themselves as leaders by setting internal standards that exceed the strictest laws. This reduces liability and builds trust with stakeholders who see consistency across regions. Finally, evidence packages provide the documentation that turns compliance into defensibility. These packages include written policies, signed consent forms, destruction certificates, training logs, audit reports, and vendor contracts. Together, they serve as proof points that the organization has not only designed compliant systems but also operated them consistently. For example, in response to an audit or lawsuit, a company could present an evidence package showing retention schedules, consent logs, and documented destruction of templates. This ability to produce verifiable records is often the difference between theoretical compliance and enforceable assurance. For learners, evidence packages embody the principle of accountability. They demonstrate that privacy promises are more than words. They are documented, repeatable practices that can withstand scrutiny. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.